If your employer has recently requested that you accept a new and lesser role within the organization, you may be wondering whether your employer is legally allowed to do this. Hi, I'm Mike from Cashion Legal, and in this video, I'm going to cover the concept of demotions. Specifically, I'm going to cover what constitutes a demotion, whether your employer is permitted to impose a demotion, and what you might be able to do in the circumstances. Let's start with the context. Assessing the legality of any job change begins with consideration of two competing principles. On the one hand, you have the employer's ability to manage their business as they see fit. The courts recognize that businesses face external factors that require them to adapt and change to new circumstances. For that reason, the courts will allow employers to make certain changes to an employee's role to adapt to new circumstances. On the other hand, the courts do not permit employers to make fundamental changes to an employee's employment agreement. This means that an employee will not be required to accept a new role imposed by their employer if it fundamentally changes the nature of their employment. Given these competing principles, every job change must be assessed on its own merits to determine whether or not it is allowable. At this juncture, I will point out that if your employer has asked you to take a new role within the organization, it is never too early to seek legal advice. Navigating the situation can be very challenging, and there are significant implications to all of your conduct throughout this process. For that reason, if you're wondering what steps to take next, I encourage you to click the link to our website in the description to this video and book a consultation. What are some of the factors the courts will look at in determining whether a job change is permitted? This analysis always starts with a review of your employment contract. If your employment contract specifically contemplates your employer's ability to make changes to your role, this provides your employer with a significant amount of latitude in this process. Conversely, your employment contract might not include this language and might actually specifically guarantee you a particular role. If that is the case, this would significantly limit your employer's ability to change your job. Another important consideration is the nature of the requested change. Any request to assume a substantially similar role is more likely to be accepted than a request to assume a substantially different role. The more similar that a role is to your current role, the more likely it is that the courts will view the request to assume that role as being reasonable. Surrounding circumstances of the requested change are also important. If your employer can identify genuine business factors outside of its control that are precipitating the change, this strengthens their ability to request that you assume a new role. Conversely, in the absence of these factors, this would reduce the employer's ability to impose a change. Beyond these factors, there are certain circumstances where the courts have recognized that job changes are generally not permissible. The courts have recognized that these circumstances are indicative of a demotion, which is understood to be a form of constructive dismissal. Some of the circumstances that courts have recognized as indicative of a demotion include a reduction in pay, a reduction in hierarchy, a loss of direct reports, a loss of managerial responsibilities, or any change that is implemented in connection with discipline. Courts have been fairly consistent that job changes in these circumstances constitute demotions and are therefore not permissible. There's a well-recognized understanding at law that employees are not required to accept roles that would be humiliating or would cause them to experience a loss of prestige within the workplace. If your employer is asking you to take a new role and accepting this new role would be demeaning, embarrassing, or humiliating, you are likely not required to accept this new role. As I indicated earlier, if your employer has requested that you accept a new role, it is never too early to seek legal advice. How you respond could have significant implications for your situation. If you're not agreeable to the new role, is to communicate your disagreement to your employer in writing as soon as possible. It is important to be firm, professional, and respectful in this communication. If you do not object to the new role soon enough, you may be seen as having acquiesced or consented to the new role. This would remove your ability to challenge these changes at a later date. Once you raise your concerns with your employer in writing, they may write back and rescind the changes or propose an acceptable compromise. If your employer proposes a solution that is acceptable, then you can move forward on that basis. However, if your employer insists that you take the new role, you then have the option to pursue a claim for constructive dismissal. Constructive dismissal refers to any situation where the employer commits a fundamental breach of the employment agreement. In this situation, you are permitted to resign and pursue a claim against your employer for severance. This is a very serious step and should only be pursued where it absolutely makes sense for your circumstances. If your employer has recently requested that you accept a new role and you're wondering what to do, we can assist you with this. We provide employees facing job changes with clarity about their situation, strategy for next step, and peace of mind through sound advice and strong representation. If you have questions about how to proceed, click the link to our website in the description to this video and book a consultation today.